Hello everyone and welcome to LawPutra YouTube channel. A topic of discussion today is electronic evidence. When we talk about electronic evidence, what is the first thing that comes to your mind? Emails, photographs, CDs, DVDs, etc., right? But to understand electronic evidence, it is important to understand evidence. So, according to Section 3 of the Indian Evidence Act, evidence means and includes oral evidence, which is the statements made by witnesses in a court of law, and it also includes documentary evidence, which includes the documents or electronic records. So, to understand this, electronic records form part or come within the ambit of documentary evidence. With the advent of technology and to meet the need of times, the Information Technology Act was drafted in the year 2000. The Information Technology Act amends various Indian laws, including the Indian Evidence Act. The Evidence Act was amended by virtue of Section 92 of the IT Act 2000. The term electronic record has been defined under Section 2, subsection 1, clause T of the Information Technology Act 2000. Electronic record means data, record, data generated, image, sound stored, received or sent in electronic form or microfilm or computer generated microfiche. There are several sections of the Indian Evidence Act that deal with electronic record. However, today we are going to talk about Section 65A and 65B of the Indian Evidence Act. Section 65A and 65B of the Indian Evidence Act deals specifically with the admissibility of electronic record. Section 65A of the Indian Evidence Act specifically provides that contents of electronic record may be proved in accordance with the provisions given in Section 65B. Now let's move on to Section 65B. It is Section 65B that lays down the procedure in which the electronic records are to be proved in a court of law. It states that any information contained in electronic form which is printed on a paper, stored, recorded or copied in optical or magnetic media produced by a computer shall be deemed to be a document. As we have studied in Section 3, Section 65B lays down 4 conditions that have to be satisfied in order for an electronic record to be made admissible. The first condition is that at the time the electronic record that was produced by a computer must have been in regular use. The second condition is the kind of information that is contained in the electronic record must have been regularly and ordinarily fed to the computer. The third condition is that the computer must have been operating properly. And the fourth and final condition is that the duplicate copy that is being produced, it must be a reproduction of the original electronic record. Section 65B subsection 3 also states that if the user has been using a network device, then all the devices that are connected will be considered a single device. Section 65B subsection 4 talks about the certificate of authenticity. The purpose of a certificate is to satisfy the conditions that have been laid down in subsection 2 of 65B. However, whether this certificate is mandatory or discretionary has been a point of contention over various case laws. A very important case in this regard is that of Anwar PV versus PK Bashir, the judgment which came out in 2014. This particular case states that this certificate is mandatory and has to be produced along with the evidence for the evidence to be admissible in a court of law. But in the year 2018, in the case of Shafi Muhammad versus State of Himachal Pradesh, it was held that this particular certificate is merely a procedure and so it can be relaxed by the courts. But recently, the case of Arjun Pandit Rao Khotkar versus Kailash Kushan Rao, the judgment which was given on 14 July 2020, overruled the Shafi Muhammad case. And it also clarified that if the device itself is produced, like a laptop, a mobile phone is produced in the court of law, then there is no need for the certificate. So to simply understand, if the evidence you are giving in the court of law is bulky and you cannot produce the device itself, then you have to give a certificate. But for example, your WhatsApp messages are your evidence, and so you can just give your phone without the need of a certificate. With that, I would like to conclude this session and I hope I was able to supplement something to your knowledge. Thank you very much for watching LawPutra.